Ready? Start. Sir, it has to be seen that the question of contributory negligence arises when there has been some act or omission on the part of the claimant who has materially contributed to the cause of the accident. Stop. Negligence ordinarily means breach of a legal duty to take care, but contributory negligence means the failure by a person to use reasonable care for the safety of either he himself or for the safety of his property, so that he becomes blameworthy for his own act. Stop para. As stated herein above, the respondents have failed to lead any evidence, and as such the testimony of both the PWs, which is corroborative of each other, remains uncontroverted and unchallenged, because the same has not been shaken even in their cross examination. Stop. To my mind, merely because some eyewitness has not been examined, the same does not mean that the petitioners have failed to prove the rashness and negligence on the part of the respondent number 1. Stop. I am also of the opinion that the submission of the learned counsel for the respondent number 3 pertaining to the helmets of the petitioners is also of no use. Stop. The petitioner, who has examined himself as PW1, has described the nature of injuries in his evidence by way of affidavit exhibit PW1 over A on record. Stop. The discharge summary as PW1 over 4 is there on record to show that the petitioner remained admitted in the hospital. Stop. The petitioner has not claimed any amount under this head in the claim petition. Stop. There is not even a single pleading to this effect of the petitioner in the entire claim petition. Stop. As such, to my mind, the petitioner is not entitled for any amount under this head. Stop. Though there is no cogent evidence on record for the money spent by the petitioner for conveyance, yet considering the nature of injuries suffered by the petitioner, I am of the opinion that petitioner must have spent some sum under this head. Stop para. Hence, I hereby grant compensation of rupees 10,000 for expenses incurred on conveyance and special diet. Stop. The claimant suffers a permanent disability as a result of injuries. The assessment of compensation under the head of loss of future earnings would depend upon the effect and impact of such permanent disability on his earning capacity. Stop. The tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity. Stop. In most of the cases, the percentage of economic loss, that is, percentage of loss of earning capacity arising from a permanent disability, will be different from the percentage of permanent disability. Stop. In the case in hand, as per the own assertion of the petitioner is not a government employee. Stop. The wife of the petitioner is a housewife as claimed by her in MACT petition number 47 of 2016, which has not been disputed by the respondents. Stop. Considering the facts and circumstances of the present facts, I hereby grant compensation of rupees 10,000 towards loss of amenities of life. Stop.